Give me 1 second while it loads. Okay, you guys are good to go.
Great. Monitor, we're ready to begin trial. Is that right?
Correct.
All right, fantastic. So I'll be the ruling judge for you all this afternoon. Plaintiff's side, are you all ready for trial?
We are, Your Honor.
Defendant's side, are you ready?
Yes, Your Honor.
All right, and I'm presuming that our scoring panelists all have their trial roster and scoring sheets. Let me know if that's not the case.
I do not have a trial roster.
I don't have a trial roster either.
I don't either.
Well, that's interesting. My instructions indicate that all the scoring panelists should have a trial roster. Did these scoring sheets have them incorporated?
It doesn't look like it.
Your Honor, the defense has put their trial roster in the chat.
All right, thank you very much. Can plaintiff's counsel do the same?
Yes, Your Honor. Just one moment, please, so we do that.
Your Honor, while we wait, I missed the code for plaintiff and defense. Do we have those?
I'm sorry, I was having difficulty hearing you. Could you repeat that, please?
I didn't see the code for the teams.
The team code? Interesting. Well, why don't we, well, we haven't started yet, so why don't we take a break while we try and work out some of these technical difficulties. If plaintiff's counsel, I see we have defense counsel roster in the chat. Plaintiff's counsel, don't see yours in the chat yet.
We put a typed out version of the roster in the chat. We can also try and find a link if you would like that.
Okay, okay, I see this now. Do you have your team code there?
Yes, Team Brazil.
Okay, so that's the team code.
Yeah.
All right, so then was that a question from one of the judging panelists for the team code for the defense? Okay, so plaintiff's team code is Brazil, is that correct?
Yes, Your Honor.
And defense team code would be Morocco?
Yes, Your Honor.
Does that resolve any of the difficulties we have with team codes?
Yes, thank you.
Great. All right, it looks like we've got the video stream is going. All right, so now I will inform the teams as well as anybody participating in the panelists and spectating that the Colorado Bar Association may be taking photographs of the competition, or I suppose video as well, and that team participation in the state tournament grants automatic permission and use of these photos by the Colorado Bar Association. Anyone who is in the gallery who is connected with the teams and not competing in that round should leave the courtroom. There are two exceptions to this rule. Somebody please let me know if any of the exceptions apply. I believe they have to do with family members and coaches. The team should be reminded that no recesses will be taken during the course of the trial except upon emergency. All right, I will ask the scoring panelists to indicate if any of them has any reason to be biased in judging either team, and that if any of the panelists is so concerned, notify me at this time. Hearing nothing, we will move on. I will remind the teams and the coaches that any disputes arising out of the competition must be reported in accordance with the competition rules, and that time compliance requirements will be strictly enforced and considered as part of your individual scoring performances. No coach or team member, other than a timekeeper, should be seated in the jury box, since we're all remote. I'm not sure that that's very applicable today. And I'd like you at this time to ask each of the teams, beginning with plaintiff, to introduce each of their team members and their roles today. Starting with plaintiffs, please.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Ella Walters, and today I will be delivering the opening statements on behalf of the prosecution, conducting the direct examination of Kyle Cusack and the cross-examination of Professor Blake Van Owen.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Lily Radowski, and today I'll be conducting the direct examination of Jordan Markowitz and the cross-examination of Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Jordan Ryan, and today I'll be conducting the direct examination of Alex Fuentes, the cross-examination of Avery Becker, as well as presenting closing arguments on behalf of the prosecution. At this time, may our witnesses please introduce themselves.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Longi, and today I am Alex Fuentes.
Good afternoon, Your Honor, and members of the jury. My name is Braden Kerr, and today I am Kyle Cusack.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Charlotte Combe, and today I am Detective Jordan Markowitz.
Defense team.
Good afternoon, Your Honor, counsel, and members of the jury. My name is Chalmers Powell, and I represent the defendant, Avery Becker.
Good afternoon, Your Honor, counsel, members of the jury. My name is Ashlyn Bierick, and I represent the defendant in today's case.
Good afternoon, Your Honor, counsel, members of the jury. My name is Madeline Proctor, and today I represent the defendant, Avery Becker.
Your Honor, may our witnesses now introduce themselves?
Yes.
Good afternoon, Your Honor, counsel, members of the jury. My name is Trendon Schultz, and I am Taylor Perkins.
Good evening, Your Honor, counsel, members of the jury. My name is Jordan Merriweather, and I am Blake Van Owen.
Good afternoon, Your Honor, counsel, members of the jury. My name is Juliette Bruner, and I am Avery Becker.
I believe that's all of our team participants. If it's not, please let me know right now. All right, hearing nothing, we'll move forward. At this point, I would like all of the team members, plaintiff and defense teams, to raise their right hands as I swear you in at this time. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do. Yes, Your Honor.
Further, witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do.
I do.
Yes, Your Honor.
Now, this is the part for the gallery members. Thank you, team. Gallery members, including the teachers and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as a positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I'll presume I'm getting affirmative responses since we've blocked everyone out of the virtual competition. Now, scoring panelists, please raise your right hands for swearing in. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
Thank you. Everyone is now sworn in. We're ready to proceed with the next phase. Plaintiff's counsel, do you have any opening statements?
We do, Your Honor, but first a few preliminary matters. Primarily, we ask that these stipulations be constructively read into the record and published to the jury.
And by that, you're asking the court to take notice of the stipulation?
Yes, Your Honor.
We shall do so. Anything else?
Yes. If at any time the court cannot see or hear a witness or lawyer speaking or something being screen shared, we ask that the court intervene so that we may fix the problem.
I will try and do so. Thank you. Any other matters?
Yes, Your Honor. We ask in accordance with Tournament Rule 7.4 that once documents have been admitted into evidence, that we be allowed to mark on them with Zoom annotation features.
We will handle that. If there are any objections at the time, we'll take those under consideration. Otherwise, you may proceed.
Lastly, Your Honor, we just ask that any time remaining at the end of the prosecution closing be left for rebuttal.
If you have saved time, I'll defer to the timekeeper on how that is going to be managed. Thank you.
Thank you, Your Honor. No further preliminary matters.
All right. Well, then let's hear the opening statement. If you're prepared.
Your Honor, the defense has two preliminary matters, if you don't mind.
Oh, no.
Firstly, the defense requests the court to take judicial notice of the complaint filed against Avery Becker.
I'll take notice of the court file, yes.
And then secondly, Your Honor, I've noticed that there was a trial technician along with a timekeeper for the prosecution. Pursuant to the rules of competition, this isn't allowed, and we would ask that only participating members of this round be in the Zoom.
Plaintiffs, do you have a response to that?
Yes, Your Honor. Both our timekeeper and trial technician are competing members in this round and are assisting with this round.
Your Honor, may I?
Yes.
Your Honor, a minimum of 6 people can participate, but they're in the rules of competition. There aren't any provisions for trial technicians.
Your Honor, if I may.
Yes.
The use of screen sharing documents under the virtual competition rules has been allowed to be done by co-counsels and by counsels presenting, as well as by trial technicians, specifically because of the virtual situation that we're doing this tournament in.
I'm going to go ahead, because of the certain special circumstance that we're in, I'm going to go ahead and allow that technician. And I understand that the technician and timekeepers are listed as members of the team. So both of those will be allowed. Objections overruled.
With that, Your Honor, the defense is ready to proceed.
All right, then let's begin.
Your Honor, if I may have a moment to set up my space.
Yes.
She wanted revenge. She got more than she bargained for. On March 6th, 2020, Avery Becker was mad. After all, how could she not be? She had just been kicked off her school's mock trial team, a team that she had been a part of since freshman year, a team that she had poured her heart and soul and time into, all for her coach to rip it away. She begged her coach, Mackenzie Brackman, to let her back on the team, but he ignored her. After Miss Becker's expulsion from the team, she wanted revenge. So she vowed to get back at her coach, even if it was the last thing she ever did. Members of the jury, you'll hear that when Miss Becker went to the scene, she got more than she bargained for. Fueled by her anger and her hurt, she came up with a plan to get even, a plan to vandalize Mr. Brackman's home. But like I said, you'll hear that she got more than she bargained for. She didn't expect Mr. Brackman to be home, but he was. She didn't expect Mr. Brackman to have a knife, but he did. She didn't expect a struggle to ensue, and members of the jury, she didn't expect to kill Mr. Brackman, but she did. You'll hear that she wanted revenge, and she got more than she bargained for. In today's case, the defendant Avery Becker has been charged with burglary in the second degree and felony murder in the first. As the prosecution, we hold the burden of proof, which means that we must prove to you beyond a reasonable doubt that the defendant Avery Becker went to the Brackman residence intending to cause damage to the Brackman property, and while the defendant was there, Mr. Brackman was killed. Now, members of the jury, we don't have to prove to you that Miss Becker went to the Brackman residence with the intent to kill, but simply that while Miss Becker was there, Mr. Brackman was killed. We'll meet this burden by proving to you that it was the defendant Avery Becker who came up with the plan to break in and vandalize Mr. Brackman's home. That it was the defendant Avery Becker who killed Mackenzie Brackman. She wanted revenge. She got more than she bargained for. First, members of the jury, you'll hear from a friend of the defendant, Alex Cifuentes, about the rocky relationship between Mr. Brackman and Miss Becker. She'll tell you about a series of text conversations that took place between herself and the defendant just days before Mr. Brackman was killed. And she'll tell you that in these text conversations, the defendant Avery Becker planned to break in and vandalize Mr. Brackman's home. Next, members of the jury, you'll hear from an expert in crime scene reconstruction, Kyle Kuzak, about the physical evidence found at the scene. He'll tell you that this physical evidence shows that a struggle occurred over a knife and that this horrific tragedy was the direct result of a break-in gone wrong. Finally, members of the jury, you'll hear from a detective, Detective Jordan Markowitz, about the defendant's cell phone records. She'll tell you that these records show that the defendant's phone connected to the cell tower nearest the Brackman residence not once, not twice, but 3 separate times on the day that Mr. Brackman was killed. And members of the jury, she'll tell you that these records show that the defendant Avery Becker was at the Brackman residence around the time of the murder. She wanted revenge, and she got more than she bargained for. At the end of today's trial, my co-counsel Jordan Ryan will stand before you and tell you that the defendant Avery Becker wanted revenge. And members of the jury, you'll see that she got more than she bargained for. She will ask you to find the defendant guilty. Thank you.
Defense counsel, you're prepared?
Yes, Your Honor.
You may proceed.
Justice doesn't come in a box with a picture on top. It's Friday, March 6th. Detective Markowitz gets a call to the home of Mackenzie Brackman. Mr. Brackman is dead on the floor, and there's a bloody knife nearby. She continues to investigate, but she did not have any fingerprints. She did not have any DNA. She did not have any suspects. Racing to find one, she calls a single member of the mock trial team, Alex Fuentes, who immediately points the finger at Avery Becker, and the detective zeroes in. See, the detective had more than he bargained for. In an effort to make all the pieces line up with Avery Becker, the detective misses key pieces along the way. The credible suspect, the credible alibi, the alternate suspect, and the scheming witness. Avery Becker was a senior at Colorado High School. She was the star of the mock trial team. People like Alex Fuentes and Mr. Brackman wished she would work harder. Ms. Becker is talented, but she isn't perfect. When Mr. Brackman told her she didn't deserve any of the awards she had won at the regional tournament, she let her emotions get the best of her, and she was kicked off the mock trial team. She went home and licked her wounds. But she did not want revenge. She wanted to make amends. And she did not put on a mask and break into Mr. Brackman's home. And she did not stab him in the back. Good afternoon, Your Honor, counsel, members of the jury. My name is Ashlyn Vierick. And together with Chalmers Powell and Madeline Proctor, we have the privilege of representing Miss Avery Becker in today's trial. The prosecution must prove to you each and every element of each and every crime. They will fail you. As they do, pay attention to three things: the screenshots, the cell tower records, and the stronger suspect. Screenshots. Detective Markowitz let Alex Fuentes send her screenshots. What she claims came from Avery Becker. Though the detective says she is an expert in cell phone data recovery, she did not recover any data. She did not confirm that Avery Becker sent these text messages. She did not question that Alex Fuentes took a full day to send these screenshots. And she did not question that Alex Fuentes forgot her phone on the day of the interview in the first place. Can the prosecution really prove that Avery Becker sent these text messages? Cell tower records. These records are just vague and just strong enough to point the finger, but too vague to prove anything. They won't show you where Avery Becker was on the day of the murder. She was with Taylor Perkins all day. They won't show you if she had her phone. She didn't. Alex Fuentes was the last one with it. And most importantly, these records won't rule out any alternate suspects whom Detective Markowitz failed to investigate. Ask yourselves, what do these records really prove? Stronger suspect. A fellow student at Colorado High School, Blair Rollins. Blair's father was convicted of murder and sentenced to life in prison. His attorney, Mackenzie Brackman. Blair Rollins only lived a few blocks away from Avery Becker, and Blair Rollins was never interviewed for today's trial. To this day, no one knows where he is. Why did no one question Rollins? At the end of this trial, Miss Madeline Proctor will walk with you through the minefield of reasonable doubt. The ignored screenshots, the ignored alibi, and the ignored alternate suspect. She will ask you for a verdict of not guilty
because justice doesn't come in a puzzle box with a picture on top. Thank you.
Prosecution, you may now begin with your case.
The prosecution calls Alex Cifuentes to the stand. Please introduce yourself for the jury.
Good afternoon, y'all. My name is Alexandria Cifuentes.
Tell us just a little bit about yourself, Ms. Cifuentes.
Well, about 7 years ago, I took a physical journey here from Fort Worth, Texas. I moved. And around that time, I began my spiritual journey through the use of yoga and tarot cards.
How do you spend your time?
Well, I go to yoga once a week, and I read tarot from time to time, but I also enjoy doing mock trial.
Where do you participate in mock trial?
At CHS, also known as Colorado High School.
Do you know the defendant, Avery Becker?
Avery, bless her heart. She introduced me to mock trial.
Ms. Cifuentes, before we get any further, could you tell us what exactly is mock trial?
Oh, Lord, it is such a fun activity. It's kind of like a play. We high school students get to take on the roles of lawyers and witnesses and present the case to be judged. It is so much fun.
Does it take a lot of time to prepare for mock trial?
Of course it does.
And who coached yourself and Avery Becker on your mock trial team?
Mr. B, Coach Mackenzie Brackman. Man, he was just the kindest Aries I ever met, and he always had this gentle blue aura about him.
Ms. Cifuentes, did your teammates and yourself get along with Mr. Brackman?
We sure did, for the most part.
What do you mean, for the most part?
Well, Avery, she had a habit of showing up late, and she could be lazier than a hound dog on a summer's day sometime. And regionals was almost a disaster.
Why was it almost a disaster?
Well, Avery had been doing her thing of showing up late, not being prepared. So Coach B demoted her down to the B team. And somehow Avery wormed her way back up to the A team. I don't really know what happened, but it was a fiasco.
Well, how did your regional tournament go even after that fiasco?
It went real well. We ain't CHS for nothing. We qualified for state, and Avery even won a couple awards.
What did your team have to do to prepare for state?
We had to practice real hard. It was actually at practice a couple days after the competition when something happened.
Could you tell us what that was?
Coach B and Avery, they got into an argument. I mean, I can't blame them. They are both Aries. But it was about Avery's awards.
What did the defendant do as a result of that argument?
Avery stormed out. Coach B followed her, and I don't really know what happened between them, but I do know that Avery was permanently kicked off the team.
Well, Ms. Cifuentes, even after the defendant was permanently off the team, did the two of you stay in contact?
We did. Avery texted me.
Would you recognize pictures of those texts if I showed them to you?
I would.
Your Honor, at this time, I ask if my co-counsel may begin screen sharing Exhibit 14.
Yes.
Ms. Cifuentes, could you tell us what are these?
Those are the texts between myself and Avery.
Are they fair and accurate representations of the text you received?
Yes, they are.
Have they been changed or altered in any way since they were originally sent?
No, not at all.
To be clear, who sent you these text messages?
Miss Avery Becker did.
Your Honor, at this time, we move to admit Exhibit 14 into evidence.
It's admitted.
Objection, Your Honor, to the admittance of this exhibit under Rule 801 hearsay.
Prosecution, do you have a response to that?
Yes, Your Honor. Under Rule 801D2, those text messages in gray are statements of a party opponent as they were sent by Avery Becker. The texts sent by Ms. Cifuentes are not being used for the truth of the matter asserted, but rather for the effect on the listener.
Response, Your Honor.
You may.
Your Honor, there has not been any proper foundation that these text messages were sent by Avery Becker, and Ms. Cifuentes is not able to lay this foundation. The accuracy of these text messages are at dispute, and we do not truly think that Avery Becker sent these text messages, so the exception of party opponent cannot be used.
May I respond, Your Honor?
Well, counsel, why don't you build on that through some examination and move to admit that after a few more questions?
No. Ms. Cifuentes, who again sent you these text messages?
Miss Avery Becker did. We had texted a couple times before.
And is this the original conversation you had with Ms. Becker?
Yes, ma'am, it is.
Your Honor, at this time, we move to admit Exhibit 14 into evidence. The foundation that it was the defendant, Avery Becker, who sent these texts. This witness has testified to that fact multiple times, which is acceptable under the rules of evidence.
Counsel, I've heard the objections. Unless there's a different new objection, I've heard all the arguments, and I will allow the admission of Exhibit 14.
Ms. Cifuentes, what did the defendant originally text you about?
Avery had texted me about getting back on the mock trial team.
Did you try to help her with that?
Of course I did. I'm a Gemini. I don't abandon my friends.
Were you successful?
I was not. You know, I charged my crystals under the full moon, and I real hoped the stars would align in Avery's favor, but Mr. B was not hearing me.
Did you tell the defendant they weren't going to be let back onto the mock trial team?
I did, and Avery's reaction to that, well, it worried me.
Ms. Radowski, if we could get that exhibit back, please. Ms. Cifuentes, why did the reaction worry you?
After I told Avery she wouldn't be back on the team, Avery texted and said, well, if he's still upset about his car, then he's gonna be real upset when he sees what I do to his house.
How did you respond to that?
I asked what Avery was gonna do.
And what did the defendant tell you?
I'm gonna wait until he's at work and break in and trash it. That's what Avery texted.
Thank you, Your Honor. No further questions. I also ask at this time that we preserve the markings on this document for use in closing arguments.
That's fine. Is there any cross-examination of this witness?
Yes, Your Honor.
You may proceed.
Good afternoon, Ms. Cifuentes.
Good afternoon, darling.
Let's talk about your mock trial experience. You were close friends with Avery Becker.
I was.
You believed you were equal when it came to mock trial.
I do believe that, yes.
You often came prepared to practice.
I did. You know, my favorite way to practice examinations was to my crystals.
Yes, but Miss Becker often came late to practice.
She did.
But Miss Becker was the one who won awards for her performances.
She did win awards, that's correct.
Eventually, you got to a point where you asked Coach Brackman why he put up with Avery Becker.
I did ask Coach B that.
You even went so far as to ask why he kept her on the team.
I did ask that.
Now, Avery Becker was demoted to B team.
Yes, she was.
You believed she was rightfully demoted.
I do. Avery was lazy and she wasn't often prepared, so I thought that Coach B made the correct decision with that.
But Avery was brought back to the team.
She was, yes.
Eventually, she was kicked off entirely.
That's correct. I heard somewhere along the grapevine that she had vandalized a car.
Eventually, you believed the team was better off.
I did. Her lateness and lack of preparation often caused us stress, so I did think that the team was a lot better off.
You were excited to take on larger roles now that your best friend was off the team.
I was excited for my larger roles.
Now let's talk about the text you received. Like you mentioned earlier, Avery Becker was kicked off the team.
Yes, I did.
And afterwards, you received the text.
I did, yes.
And Avery was begging for help.
She was, yes.
So you made an impassioned plea to Mr. Brackman.
I did. I even charged my favorite amethyst crystal for her just to help with her goal to get back on the team.
But your crystal or your plea didn't help Miss Becker, did it?
It did not. The stars were not aligning for her.
So you texted Miss Becker that Mr. Brackman wasn't backing down.
I did.
You should have access to Exhibit 14, so please look back at this.
I don't currently have it in front of me. Would you mind showing me?
Yes, if Mr. Powell could share this exhibit. Now, starting at the 5th bubble down, Miss Becker continues to ask for help.
She does.
You respond by saying, I guess I could try.
I do.
You don't say, I will help, do you?
That was my response. I think it's pretty clear that I was going to help out.
I'm not asking what you meant by your response. I'm just asking, you didn't say, I will help, did you?
I was going to help Avery, yes.
So that's a yes. You did not say specifically, I will help.
Those were not my specific words, but that was what I intended.
Also, nowhere within these text messages does it say, Mr. Brackman isn't backing down, does it?
It doesn't say that, but I believe it's implied in some of the messages.
But Ms. Cifuentes, like we talked about, in your own words, you said you sent a text message that said Mr. Brackman wasn't backing down.
He had made his decision.
Ms. Cifuentes, that's not my question. My question was, earlier on, in your own words, you said you texted Avery Becker that Mr. Brackman wasn't backing down. And your answer is a yes.
That was what I intended to let Avery know about.
Thank you, Ms. Fuentes. Mr. Powell, you can take down this exhibit. Now let's talk about how you handled these text messages. Mr. Brackman was your idol.
He was. I looked up to him a great deal.
You even appreciated his blue aura.
I did, yes.
But when you received direct threats aimed at Mr. Brackman, you didn't show them to him?
No, I did not. I didn't think Avery was capable of murder.
So that's a yes. You did not show them to Mr. Brackman.
It's a yes.
But when Detective Markowitz called, you immediately offered them up as evidence.
Well, when the police call, I'm not withholding stuff from them.
So he called you down for an interview at the station.
Yes.
And at this interview, you talked about the text messages and your mock trial team and Avery Becker.
We did.
You didn't bring your phone to this interview, did you?
Oh my, it's been pesky with the charging like my crystals. So I had left it charging that I must have spaced when I went to the interview.
So you didn't bring your phone to the interview?
I didn't. I offered to bring it back for the detective.
But the detective told you you could send screenshots.
That was what I was told, yes.
You didn't send those screenshots the second you got home after just being interviewed about a murder, did you, Miss Cifuentes?
I sent the screenshots as soon as possible.
Miss Cifuentes, that's not my question. I'm saying you did not send these screenshots the second you got home.
I sent them as soon as it was possible for me to do so.
Miss Cifuentes, that was not my question. I'm asking, you did not send them the second you got home after a murder investigation, and your answer is a yes.
It is a yes, but I sent them as soon as I possibly could.
You sent them the next day.
That was when it was reasonable for me to send them.
No further questions, Your Honor.
Does the prosecution have any redirect?
No redirect, Your Honor.
Witness may step down. Call your next witness, please.
This time, the prosecution calls Kyle Kuzak to the stand.
Okay, here we go. There, okay. Is that all good? Sorry about that. My grandkids were messing with my computer before I got on here.
That's all right, Mr. Kuzak. Could you start by please introducing yourself to the jury?
Good afternoon. My name is Kyle Kuzak.
What do you do for a living?
I'm a crime scene reconstructor.
Could you briefly describe what crime scene reconstruction is?
Oh, of course. Crime scene reconstruction is basically the practice of taking all of the evidence from a particular case and using that to reconstruct a plausible scenario for what could have happened.
Do you specialize in anything?
Oh, of course. I specialize in complex crimes like homicide, burglary, and home invasion.
What experience do you have?
I've spent the last 19 years doing this, and I'm actually only a few days away from retirement.
Congratulations, Mr. Kuzak.
Yeah.
Were you certified for your position?
Of course I was.
By who?
I was certified by the Colorado Bureau of Investigation.
How are you involved in today's case?
I was the chief crime scene reconstructor for the police.
What facts or evidence did you rely on to come to your conclusion?
Well, I reviewed the police report, I viewed some of the exhibits, and I also was able to visit the crime scene over the course of my investigation.
What methods did you use?
Oh, I used the standard Bevel and Gardner 7-step procedure.
At this time, the prosecution wishes to tender Mr. Kuzak as an expert in crime scene reconstruction.
Anything from the defense?
No objection from the testimony of Mr. Kuzak as an expert in those fields.
The court accepts him as an expert in crime scene investigation. You may proceed.
Yes, Your Honor. Mr. Kuzak, now I'd like to talk to you some about your investigation. Did you visit the crime scene?
Oh, of course I did.
Are you aware of what was found?
Unfortunately, I am.
What was found?
God, I haven't seen a crime scene like this since the first Bush administration, but they found a young 55-year-old man laying face down in a pool of blood.
Was a murder weapon found?
Yes.
What was it?
It was a large kitchen knife that was also covered in blood, found right near the body.
Would you recognize both the picture of the body and the knife if I showed them to you?
I would.
Your Honor, permission for my co-counsel to begin screen sharing Exhibit 4 and Exhibit 5?
Yes, go ahead.
Mr. Kuzak, do you recognize Exhibit 4?
I do.
Exhibit 5?
I also recognize this.
What is Exhibit 4?
Exhibit 4 is a picture of the body.
What is Exhibit 5?
Exhibit 5 is a picture of what we believe to be the murder weapon.
Are these fair and accurate depictions of both Exhibit 4 and Exhibit 5?
They are.
Do they appear to have been altered in any way?
They do not appear to be altered.
At this time, the prosecution wishes to admit both Exhibit 4 and Exhibit 5 into evidence.
Counsel,
No objection to 4 or 5, Your Honor.
they are admitted.
Now, Mr. Kuzak, were you able to determine where the knife came from?
I actually was, yes.
How?
Well, we discovered that Mr. Brackman had a knife block on his kitchen counter that was missing a knife similar to the one used as the murder weapon. And we also found an open drawer of knives in Mr. Brackman's kitchen.
Were you able to determine how Mr. Brackman died?
Yes, we were.
How did Mr. Brackman die?
He was stabbed in the back after some sort of struggle occurred.
Now, Mr. Kuzak, what other evidence was found at the scene of the crime?
Well, there were also a set of scuff marks found right near the back door, as well as a broken plate found in the kitchen.
Do you know if Mr. Brackman had a security system?
He did.
What was that security system?
It's one of those newfangled Ring doorbell security systems, the kind that hook right to your phone.
Were you able to obtain video from these Ring doorbells?
Yes, we were.
Have you viewed these videos?
I have.
What do they depict?
Well, they depict some intruder approaching the front door of the Brackman residence, then after finding it locked, going around into Mr. Brackman's backyard, and then into Mr. Brackman's house through the back door. And the final video shows the intruder running out the front door.
Have these videos been identified here in court today?
They have.
What exhibit numbers? Do you know?
I believe the most relevant one for our purposes is probably Exhibit 12.
At this time, the prosecution wishes to admit Exhibit 12 into evidence.
Any objection?
No objection to 12, Your Honor.
Exhibit 12 is admitted.
Your Honor, if my co-counsel may begin screen sharing what has just been admitted as Exhibit 12.
Yes.
Your Honor, would it be possible to pause time until we get this technical difficulty resolved?
Yes, why don't we go ahead and do that? Seems that the court is having a technical difficulty out of the party's control. Why don't we go ahead and see if we can get up? There we go. All right, counsel, go ahead.
Now, Mr. Kuzak, what does Exhibit 12 depict?
Exhibit 12 depicts the intruder entering the Brackman residence.
Were you able to reach any conclusions about what happened inside the Brackman residence?
Yes, I was.
What were those conclusions?
Well, what we believe happened is Mr. Brackman was notified somehow, either by the security system or by just seeing the assailant. They were notified to the presence of the intruder, which led to Mr. Brackman going and getting a weapon to defend himself.
What happened next?
Well, then some sort of scuffle occurred between the intruder and Mr. Brackman, where unfortunately the intruder got a hold of the weapon and ended up stabbing Mr. Brackman in the back.
Were you able to reach any other conclusions about what happened at the crime scene?
Yes, I was.
What were those conclusions?
Well, the first conclusion is that the murder weapon, it came from inside of the house.
What was the second conclusion?
Second conclusion is that this crime was more of a burglary gone wrong than an intentional murder.
Were you able to come up with any other conclusions?
Yes, my final conclusion is that Mr. Brackman died after some kind of scuffle with the intruder.
Thank you. No further questions.
Defense counsel?
Yes, Your Honor. Good afternoon.
Good afternoon, young man.
Good afternoon, Mr. Kuzak. Let's talk about how you conduct your reconstructions. You began by organizing and documenting all of the evidence in this case.
Yes.
And you do that by creating a witness tracking sheet, evidence tracking sheet, and a flow chart.
Yes, I did that by creating a matrix, a tracking sheet, and a flow chart.
And you got all the information in that witness tracking sheet from the Denver Police Department.
I got it from several places, but that was my primary source.
You got it. Is it your testimony today that you got it from anywhere else than the Denver Police Department?
Most of this was through the DPD, but I did do some investigation on my own. Really?
Is it your testimony today that you did outside investigation other than your reconstruction?
Oh, you misunderstand me. I'm referring to evidence I got from the DPD rather than evidence I collected myself as a representative of the DPD.
All right, let's look at the evidence tracking sheet. Is it your testimony today that anything, or you didn't get all the information on the witness tracking sheet, or excuse me, the evidence tracking sheet from the Denver Police Department?
I got all of it through my investigation.
From the Denver Police Department. Is it your testimony today that you conducted an outside of your reconstruction and investigation?
No, I operate as a civilian employee of the Denver Police Department.
Okay. So to be clear, you got your information from the evidence tracking sheet from the Denver Police Department.
Some of it came from other segments of the Denver Police Department, but some of it came from my investigation as a function of the Denver Police Department.
Okay. And all that information in both the evidence tracking sheet and witness information tracking sheet is correct?
I believe all of it is.
And if something wasn't correct, you would change it or take it out, right?
Yes.
All right, let's move on to the evidence you track. In your evidence tracking sheet, you identify department evidence number 102. It's the digital images downloaded by Detective Markowitz from S.
I'm sorry, young man. My eyes aren't what they used to be. Do you think it would be possible to share that so I could see it?
That's okay, Detective Mr. Kuzak. You prepared for this trial by reviewing this report, correct?
Yes.
So you have knowledge of what's in this report?
Yes, I do.
All right, I'll ask that again. Department Evidence 102, you identify as the digital images downloaded by Detective Markowitz from S2, correct?
Yes.
And S2 means suspect 2.
It means subject to.
Subject to. Okay, so let's move to your witness information tracking sheet. You identify Alice Cifuentes as suspect 2, correct?
Yes.
You also refer to Ms. Cifuentes as S2.
Yes.
So S2 means suspect 2.
Best evidence.
Counsel, do you have a response?
Your Honor, I'm asking Mr. Kuzak about his report. There's no best evidence, and that rule doesn't apply to this.
Your Honor, if I may respond, counsel is asking Mr. Kuzak to testify about exhibits that have not been admitted into evidence yet.
Well, he hasn't asked to put a document into evidence. I'm going to allow him to continue questioning, and the witness will answer to the best of his ability.
So, Mr. Kuzak, S2 means suspect 2.
It means subject to.
Okay, so let me make sure I'm getting this right. Subject to gave evidence to Detective Markowitz.
Yes.
And in your witness information tracking sheet, you identify Alex Cifuentes as S2.
Yes.
So, to be crystal clear, a suspect in this case, Alex Cifuentes, gave Detective Markowitz the screenshots being used at trial today.
I believe that these were given to Detective Markowitz as a function of her investigation.
That wasn't my question, Mr. Kuzak. Alex Cifuentes, a suspect in this murder investigation, gave Detective Markowitz the screenshots being used today at trial.
You don't understand how I conducted this report, because I identified Alex Cifuentes as a suspect very early on, and they would later become not a suspect through other pieces of investigation.
But at this time, at the beginning of your investigation, Alex Cifuentes was still a suspect.
At the beginning, but I think enough evidence will be provided to show that they were not a suspect by the end of this.
And you read Detective Markowitz's entire statement?
I reviewed the police report.
You read Detective Markowitz's entire witness statement?
I believe I reviewed the police report.
All right. And in that police report, Detective Markowitz says that she interviewed Miss Cifuentes the day after the murder.
I'm not entirely sure. If you could throw the police report up, that would very much help.
I'm asking you, as a witness in this trial, to the best of your knowledge, Detective Markowitz interviewed Alex Cifuentes the day after the murder.
I'm not entirely sure what Detective Markowitz was doing.
Okay. Let's talk about the prosecution's decisions. The murder occurred on March 6th.
It did.
And Miss Becker was charged only 18 days later on March 23rd, right?
Yes, she was.
And Mr. Kuzak, you didn't receive any of the evidence you used in your tracking sheet until June 2020, right?
Well, that's when I became aware of this evidence.
You were time, weren't you?
I wasn't in the initial investigation. My function is as a crime scene reconstructor.
You testified on direct that you visited the scene of the crime on March 6th, didn't you?
I testified on direct that I visited the scene.
Right. Thank you, Mr. Kuzak. Your Honor, I have no further questions at this time.
Any redirect?
No redirect, Your Honor.
Prosecution may call its next witness.
At this time, the prosecution calls Detective Jordan Markowitz to the stand. Good afternoon, Detective Markowitz. Would you please introduce yourself to the court?
Good afternoon. My name is Jordan Markowitz. I'm a detective with the Denver Police Department.
How are you involved in today's case?
Ma'am, I was one of the investigators regarding the death of Mackenzie Brackman.
And how long have you worked in law enforcement, Detective?
Well, I've been with the DPD for around 13 years now. I've been a detective for the past 7 years, ma'am.
Do you have any specialized training?
Yes, ma'am. The majority of my training is in regards to cell phones. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What did this certification entail?
Well, I had to pass a 3-day certification course as well as pass a certification test.
And have you had a chance to use your knowledge on cell phones in your work before?
Yes, ma'am. I've downloaded the contents of hundreds of phones at this point in time, and I've also used call detail record analysis in over 50 cases.
Did you have a chance to use your knowledge on cell phones in today's case?
I did.
At this time, the prosecution moves to tender Detective Jordan Markowitz as an expert in cell phone technology and cell data recovery.
Any objections?
Defense has no objection to the testimony of Detective Markowitz as an expert in those fields, Your Honor.
The witness is accepted as an expert in those fields.
Now, Detective, you mentioned that you were able to use your knowledge on cell phones in today's case. How were you able to do this?
Well, ma'am, I obtained a warrant early on in my investigation to look at the phone as well as the call detail records of my primary suspect, Avery Becker.
What did you obtain from this warrant?
Well, as I said, the warrant allowed me access to the defendant's phone as well as their call detail records. However, when I asked her attorneys for the cell phone, they said she had lost it. So I was only able to look at her call detail records throughout my investigation in analysis.
Where did you receive these call detail records from?
I got them from the defendant's cell service provider, ma'am.
And how do these records work?
Well, anytime someone receives a text or a call, a record of the interaction is created. Those are the call detail records. Now, these CDRs can tell us things like the amount of phones involved in the interaction, the length of the interaction, and most importantly, the cell tower with which the cell phone was communicating with in that interaction.
Why is the cell tower that the phone was communicating with important?
Well, ma'am, most generally, a cell phone will connect to a cell tower that is closest to it as it gives the cell phone its best connection. So we can tell, depending on which cell tower a cell phone connects to, the general location of a cell phone. Furthermore, at the top of each cell tower, there are 3 antennas that each cover a 120-degree arc. And depending on which antenna a cell phone connects with on top of a cell tower, we can also tell what direction a phone is coming from.
Were you able to find anything from the defendant's cell phone records?
Yes, ma'am. I was able to find a lot, actually. I made a diagram of my findings.
Would you recognize a copy of this diagram if you saw it?
I would.
Your Honor, permission to screen share what has previously been marked as Exhibit 15.
Go ahead.
Detective, what is this document?
Ma'am, this is the diagram I created, which shows the 3 different cell towers we found the defendant's phone connected to the day of the murder.
Is it a fair and accurate copy of the diagram that you made?
It is, ma'am.
Has it been changed or altered in any way since you last saw it?
No, ma'am.
At this time, the prosecution moves to enter Exhibit 15 into evidence.
No objection to Exhibit 15, Your Honor.
Exhibit 15 is admitted.
Detective, can you explain what these records showed?
Yes, ma'am. These records show, as I stated earlier, the 3 different cell towers Miss Becker's phone connected to the day of the murder. We found that her phone had 5 different connections to these 3 cell towers.
And what does it mean that the defendant's phone connected to 3 separate cell towers?
Well, ma'am, it means that the defendant's phone was traveling. The big thing with CDR analysis is you have to look at the pattern and the other cell towers involved in an interaction. You can't just look at one cell tower in isolation. So when we look at all 3 of them together, it's clear that the defendant's phone was moving.
Can you describe the connection with the first cell tower?
Yes, ma'am. The connection at the first cell tower is the uppermost cell tower, which I'm circling right now in red. We found that the defendant's phone connected to this cell tower at 12:47 p.m. the day of the murder. Now, this is important because the defendant's home is very close to the cell tower. I'm stamping it right now with a green check mark.
Can you describe the connection with the second cell tower for the jury?
The second connection we found was at this middle cell tower, which I'm circling in red right now. Now, we found that the defendant's phone connected to this cell tower at 12:55 p.m. the day of the murder. Now, this is important because this middle cell tower covers Rock Creek Parkway, which is the most logical route from Avery Becker's home to Mackenzie Brackman's home. I'm going to stamp a place on Rock Creek Parkway right now.
Can you describe the connection with the third cell tower?
The third cell tower Avery Becker's phone connected with is this bottommost one, which I'm circling right now. Avery Becker's phone connected to this cell tower 3 separate times. One at 1:05 p.m., again at 1:06 p.m., and lastly at 1:17 p.m. the day of the murder. Now, this is significant because this cell tower directly covers Mackenzie Brackman's home, which I'm stamping with a green check mark right now.
Now, Detective, can you point out where the mall is on this map?
Ma'am, the mall is above and slightly to the right of that middle cell tower. I'm going to put a green check mark on it right now.
Can you point out where the Fry Shack is?
The Fry Shack is below and slightly to the right of that middle cell tower. I'm also going to put a green check mark on it.
And just to clarify, do either of these locations align with any of the directions of the relevant cell towers?
No, ma'am. This goes back to the thing I was explaining earlier about those 3 antennas at the top of each cell tower. From the connection we found Ms. Becker's phone made that day, her phone did not connect to an antenna that covered the mall or Fry Shack.
Now, finally, Detective, what do these records indicate about the location of the defendant's phone on March 6th?
Well, ma'am, these records indicate that the defendant's phone traveled along Rock Creek Parkway, which I'm drawing right now, from 12:47 to 1:05 p.m. And that from 1:05 to 1:17 p.m., the defendant's phone was at Mackenzie Brackman's residence.
Thank you. No further questions. And Your Honor, permission to save these annotations for closing.
Are you asking that this be admitted as another exhibit?
No, Your Honor, I'm asking that we be able to preserve the annotations for use in closing argument.
Just to use as a demonstrative?
Yes, Your Honor.
That's fine as long as we have a clean copy of Exhibit 15 in the record. You may do that.
Thank you, Your Honor.
Defense counsel?
Yes, Your Honor. Good evening, Detective Markowitz.
Good evening.
My name is Madeline Proctor. Let's start with your arrival on the scene. When you arrived at 444 South Flower Street, you saw Mackenzie Brackman lying dead on the floor.
Near his front porch. Yes, ma'am.
So immediately you started trying to put the pieces together.
As per protocol, yes.
Let's talk about how you did that, starting with the Ring video footage. The Ring videos do not show any identifiable suspect.
Ma'am, we got the suspect's height and build from those Ring videos, but no other pertinent information.
So no identifiable suspect.
We got the height and build. Those are identifiable factors, ma'am.
All right, but the person in the video was not wearing was wearing a mask?
Yes, a devil mask.
And gloves and a hoodie, correct?
That is correct.
All right, so now let's talk about those call detail records you were talking about. Cell phones do not always connect to the nearest tower.
If the nearest cell tower is busy, a cell phone will connect to one that is further away, but that's rare, ma'am.
That's a yes to my question. Cell phones do not always connect to the nearest tower?
Yes, ma'am.
And those call detail records are thus not 100% accurate.
I wouldn't say that. I would say they're accurate, ma'am.
Here today that call detail records are 100% accurate?
Again, this goes back to what I was saying in direct about looking at the patterns between cell towers.
My question is not about the algorithm or how things connect. My question is it your testimony today that cell phones connect 100% of the time, that call detail records are 100% accurate?
They're not 100% accurate, but when we look at all the other cell towers, we can get an idea of where the defendant was.
I understand you'd like some time to explain, but you'll have some time for that on redirect. So if Mr. Powell could please pull up Exhibit 15, I'm sorry, that has been previously admitted. So that's the report you prepared, correct?
That's the diagram I made. Yes, ma'am.
And you'll notice that in the same cell tower arc as Miss Becker's home is Blair Rollins' house, right?
Yes, ma'am.
And if my co-counsel could please mark that. All right, so let's just get this straight. In the same cell tower arc as the defendant's home that you're trying to prove these records show her location is an alternate suspect.
Ma'am, I was looking at Avery Becker's call detail records.
That is not my question. My question is that in the same cell tower arc, Blair Rollins' house is in the same cell tower arc as the defendant, right?
Yes, it's near that first cell tower, ma'am.
All right, Mr. Powell, you can take that down. Thank you. Detective Markowitz, let's talk about what did lead you to Miss Becker then. You talked to only one of Coach Brackman's mock trial students, Alex Fuentes.
No, ma'am.
The first person you talked to on the mock trial team was Alex Fuentes.
That was the first person, but not the only person I interviewed.
Right, let's talk about that. But you talked to her and she told you about some text messages.
That's why I called her in for an interview, yes.
Right, and you were supposed to talk about the text messages at the interview.
Yes.
But she did not bring her phone?
No, ma'am, she told me she forgot it.
Right, and you never asked her why she forgot the phone?
Seeing as she's a teenager, I simply assumed she was nervous, but I never asked her no.
And you never asked her to turn around and get it?
I saw no reason to, as she could send me screenshots of those messages, ma'am.
Exactly. She sent you screenshots instead.
Yes.
And you have downloaded phones before using the Cellbrite technology.
The Cellbrite system, yes, ma'am.
And you set on direct hundreds of cell phones.
Yes, when I feel the need to, I do download information from phones.
But you never downloaded Miss Fuentes' phone?
There was no need. No, ma'am.
Not to confirm the validity of those text messages?
I had no reason to distrust Miss Fuentes, ma'am, so no.
All right, and let's talk about what you did now. You didn't investigate any suspect except for Miss Becker.
That's not true, ma'am.
Is it your testimony here today you investigated any other suspects?
Ma'am, I interviewed a lot of people as per protocol in my investigation.
Detective Markowitz, my question was not about who you interviewed. It was that you did not investigate any other suspects. Yes?
I investigated people, but I only included the information relevant to my investigation within my witness statement. If I included everything, it would be over 50 pages long.
You do not mention any other suspects in your complete report, in your complete statement for today's case.
No, it would be over 50 pages long if I did that.
Detective Markowitz, thank you. Your Honor, I have no further questions at this time.
Thank you. Any redirect?
Yes, Your Honor. Now, Detective, why didn't you download any information off of Alex Fuentes' phone?
Ma'am, I only use the Cellbrite system when there is a pertinent need to. Seeing as Ms. Fuentes could easily sent me those screenshots, there wasn't a need for me to download all the information off of her phone when she didn't bring it with her to the interview.
And how are you able to use call detail records in your investigation?
Well, ma'am, call detail records mean you have to look at the connection a cell phone makes to multiple different cell towers and see the patterns and analyze them. So looking at the patterns of the 3 different cell towers Avery Becker's phone connected to, it's clear that they show her phone traveled and was at the scene of the crime the day of the murder.
Thank you. No further questions. Your Honor, I believe you are muted.
Slight technical difficulty. Thank you. The witness may step down. The prosecution may call its next witness.
The prosecution rests, Your Honor.
is the defense prepared to proceed?
Yes, Your Honor. The defense calls Taylor Perkins to the stand. Good evening, Mr. Perkins.
Hello,
My name is Madeline Proctor. Please introduce yourself to the jury.
my name's Taylor Perkins. That's Perkins.
Mr. Perkins, where did you go to high school?
I went to high school at CHS, Colorado High School.
And did you know a Miss Avery Becker during your time there?
Of course I did. Avery was one of my best friends all throughout high school. You know, we had classes together, we hung out after school, we played video games together all the time, and we did mock trial together.
Let's talk about your mock trial team. What was Miss Becker's role?
Oh, she was an attorney on the team, the best one, I might add. She was great at making things up on the fly. She was like a stand-up comedian.
What about the other members of the team?
The other members of the team were good. I mean, personally, I think we're the favorites to win state. Our team was just that good. Just as long as arguments on the team weren't stopping our progression.
What do you mean by arguments on the team?
So unfortunately, Avery would show up late and unprepared to practice sometimes. Coach hated that more than anything. And the arguments between them really got in the way of everyone. I mean, having an argument at the start of practice kind of put everyone off.
I see. Did those arguments ever escalate?
They did. There was one time it got so bad that Avery was demoted to B team. This was completely unfair. I mean, think about it like this. It would be like the Rockies demoting Nolan Arenado to the minor leagues. It just doesn't make sense.
Did you do anything to help remedy the situation?
I did actually. You see, my position on the team was like a utility infielder. I helped the team where I could, but I wasn't the star like Avery. So I stepped down from the team so that the team could have Avery back.
And did Coach Brackman take Miss Becker back onto the A team?
Fortunately, he did. And a week later, they competed at regionals and advanced to state. And Avery won Best Attorney Award and Best Closing Argument. I mean, I'm not surprised.
That's great. Let's talk about March 6th now. What were you doing that morning?
that morning, I actually got to sleep in because I had first period off. And so did Avery. And so she came and picked me up for school. You know, we like to save gas money.
Where did you two go?
So we were actually on our way to school when I mentioned that Avery wasn't responding to my text. I thought it was kind of rude at the time. And that's when we were made aware that she had lost her phone.
Did you go look for the phone?
We did. You know, being seniors and senioritis in full effect, we decided to skip school that day and look everywhere we were the day before, like retrace our steps.
Where were you the day before?
The day before, we were at the Fry Shack and then the mall.
During your time at those locations, did you run into anyone you knew?
We did. Actually, while we were at the Fry Shack, a couple of members of the mock trial team showed up, which was really bad timing. I mean, that day Avery had just been kicked off the team for good. I mean, it was just really bad timing.
Why would that be bad timing?
Well, Avery had just been kicked off the team. I mean, there was no way she was getting back on it. And Alex Fuentes came up and talked to her, like tried to talk to her, but she came off in this super passive aggressive way, and Avery did not like it.
Speculation.
Response, Your Honor?
Go ahead.
Under 701, this is Mr. Perkins' impression of what happened on March 5th while they were at the Fry Shack. So it's rationally based on his perception.
Response, Your Honor.
Yes.
I don't believe that the witness was testifying as to his perception of things. He was testifying as to the mindset of Alex Fuentes, and there's been no foundation laid about the relationship between Mr. Perkins and Alex Fuentes.
Response, Your Honor?
I don't think a response is needed. I'm prepared to rule. It seems the witness is in fact testifying about his perceptions of the conversation, so I'll allow it. Counsel, you may continue.
Yes, Your Honor. Mr. Perkins, tell us again why it was bad timing.
It was bad timing because Alex Fuentes came up and tried to console Avery, but it did not make the situation better at all. In fact, it made it worse. Avery got up and went to the bathroom. I think she even left her phone sitting on the table. That was never the case with Avery. She always had her phone with her.
And Where was the last place that you saw the phone?
It was then sitting on the table when Avery got up to leave. I can't remember seeing it after that.
All right, and where did you end up finding the phone?
Unfortunately, we never found the phone, which really sucks for Avery. I mean, she had to spend like what, 500, like to like $1,000 on a new phone. That's really tough when you're trying to save up for college.
All right, let's talk about someone else now. Blair Rollins. How do you know him?
He was another student at CHS. I didn't know him that well though. Like I had a few classes with him, saw him around campus, but I generally tried to avoid him.
Why so?
He just kind of gave me the creepy vibes. I mean, I talked to him like
improper character evidence.
Response, Your Honor.
Go ahead.
This is not improper character evidence, as it is not being offered to show that Blair Rollins was creepy then and he is still creepy now. This is just going to show why Mr. Perkins does not know Mr. Rollins that well and why he tried to avoid him.
I'm going to overrule the objection, but let's try and keep the questions focused on the witness's actual knowledge.
Yes, Your Honor. Mr. Perkins, why would you avoid him?
well, I just didn't like the vibe he gave off, so I tried to avoid him the best I could.
All right, what do you know about the relationship between Blair Rollins and Coach Brackman?
Well, it's my understanding that Coach Brackman, my coach, defended Blair Rollins' father in a murder trial. And unfortunately, Blair Rollins' father was sentenced to life in prison.
I'm sorry, was there an objection?
Yes, lack of personal knowledge.
Response, Your Honor.
Yes.
Mr. Perkins does have personal knowledge because he was on the mock trial team, as well as the rumors he heard around the school. I can lay further foundation for the rumors if you would like to, but his relationship with his coach, with Blair Rollins, and with the people at Colorado High School makes it reasonable that he would have known this.
Your Honor, may I respond?
No need. I'm going to uphold that objection at this time. Defense counsel, if you're able to lay sufficient foundation to get that in, you may do so. But the immediate preceding response shall be stricken from the record.
Yes, Your Honor. Mr. Perkins, did you hear any rumors about Coach Brackman and Mr. Rollins around the school?
I did. I heard him around the school, and also at practices, Coach Brackman would like to keep us updated on his own trials. And so I learned about it there too.
What did you learn from those?
Well, I learned that one of Coach Brackman's clients was Blair Rollins' father, and he told us that he lost that trial.
All right, and what do you know about the relationship between Blair Rollins and Alex Cifuentes?
Well, just from what I could see, they seem like pretty good friends. Not best friends like Avery and I, but
lack of personal knowledge.
Response, Your Honor.
Yes, go ahead.
This is again based on Mr. Perkins' personal knowledge of the two, as well as seeing them around school, seeing them hanging out. If he is testifying that they appeared to be friends, not that they actually were friends, so it's not speculating on anything about their relationship. You could ask Ms. Cifuentes about that.
I'm going to sustain that objection. However, defense counsel, you can build up the foundation if you'd like to continue that line of testimony.
Yes, Your Honor. Mr. Perkins, did you ever see Ms. Cifuentes and Mr. Rollins together?
of course I did. They were together a lot at school. I mean, I always saw them talking. I mean, Alex was one of the few people who didn't think Blair was creepy.
Right. So would you say they were friends?
I would say they seem like friends, definitely.
All right. And what can you tell us about Ms. Cifuentes' relationship with Miss Becker as you observed it on the team?
Well, seeing them both on the team, I mean, I got to see them a lot because we practice mock trial a lot. I mean, you don't get that good at mock trial by not practicing. But from the time in practice, Alex kind of seemed like he didn't like Avery. I mean, Avery always got the roles that Alex wanted. I mean,
Objection,
Alex really...
lack of personal knowledge.
Response, Your Honor.
Go ahead.
Mr. Perkins testified that this was during his time on the mock trial team and from observing their interactions there. So he does indeed have personal knowledge of the interactions and what it appeared their relationship was from those practices.
Response, Your Honor.
Go ahead.
I'm not objecting as to the testimony about the relationship between Alex Cifuentes and Avery Becker. I'm objecting to the testimony that Avery always got the roles that Alex wanted, as there was no way for Mr. Perkins to know this. He has previously testified that him and Alex were not close friends, so there would be no way for him to know this.
I think that's going to, I don't think another response is needed. This seems to go to the weight of the evidence. I'm going to allow this testimony to continue.
So, Mr. Perkins, what can you tell us about the relationship between Ms. Cifuentes and Blair Rollins? Oh, sorry, Ms. Cifuentes and Ms. Becker.
Well, they were not good friends. I mean, on the surface, they got along. I mean, it was a professional setting at mock trial practice. So, you be nice to someone, you say, oh, how you doing? But it wasn't like they were really good friends.
All right. And back to Blair Rollins for a moment. Have you seen him recently?
No, I haven't. I haven't seen him in a long time, actually.
Going back to March 6th, were you and Miss Becker ever apart at any moment on that day?
No, we were together that entire day looking for her phone.
Thank you, Mr. Perkins. Your Honor, I have no further questions at this time.
All right, Counsel Cross.
Yes, Your Honor. Good afternoon, Mr. Perkins. I want to start.
Good afternoon.
I want to start by talking a little bit about the defendant's relationship with Mr. Brackman. You were on the mock trial team with Avery Becker, correct?
I was. It was a great time.
And Mr. Brackman was your coach?
He was our coach.
So throughout this time, you were able to observe the relationship, correct?
I mean, only what was going on like outwardly. I don't know what they were actually thinking like down below. Maybe it was different from what appeared.
But Mr. Perkins, you were able to observe them interacting, correct?
Oh, yes, I was. I mean, they were at practice most days.
Mr. Brackman didn't like how Avery prepared, correct?
It really didn't seem like it. He wanted a lot of work done, and Avery just rather go with the flow,
In fact, Mr. Brackman even called Avery unprepared.
Well, he did, yes.
He called Avery lazy.
I mean, that was a little harsh, but he did.
He said that she didn't try hard enough, correct?
Yeah, which, I mean, she didn't put in the work like everyone else, but she had natural talent to make up for that.
But everything that Mr. Brackman said, everything that was going on, it seemed to bother Avery, correct?
Well, if someone called you lazy and said that you didn't deserve anything you did, would you feel good about that? I mean, I wouldn't.
Mr. Perkins, that wasn't quite my question. I asked specifically about if the defendant was bothered by this, and she was, wasn't she?
I think anyone would be right, and and Avery was too.
Now, Mr. Perkins, you and Avery were on the mock trial team together for 4 years, correct?
I mean, it felt like 3 because of COVID. I mean, it really cut the year short, but yes, 4 years.
And Mr. Brackman was your coach for all 4 of those years?
Well, he was one of the coaches, yes.
Now, fast forwarding a little bit, just after regionals, the defendant was kicked off the team by Mr. Brackman, correct?
Yeah, she was, which didn't make sense to me.
But after she was kicked off, she tried everything to get back on.
Well, I mean, the way she was telling me was she tried to make things right.
But Mr. Perkins, is that a yes to my question? She tried everything to get back on?
I don't know about everything. I mean, there are limitations to what she would have done.
Mr. Perkins, I'm using your own words here. The defendant tried everything.
Your Honor, improper impeachment under Rule 613.
Response, Your Honor?
Yes, go ahead.
I am not trying to impeach the witness. I'm simply asking a clarifying question.
So, sorry, response, Your Honor?
Go ahead.
Using the witness's statement to confirm testimony without impeaching is improper impeachment, Your Honor.
Yeah. Counsel, why don't you go ahead and establish what it is you're asking about exactly if you're going to go after these statements. Otherwise, we really have no idea what the basis is for your questions. I'm going to sustain that objection, but you are free to lay the foundation as necessary.
Thank you, Your Honor. Now, Mr. Perkins, the defendant tried everything to get back on the team, correct?
I say everything, I mean that in like a metaphorical sense, not like everything.
But you even think that Avery went so far as to text everyone on the team for help.
Well, yeah, everyone that she thought could help her, of course. She was trying to get back on the team. I mean, what better way than to go through the actual team?
But Mr. Perkins, you even think that she texted Alex Cifuentes, correct?
Yeah, I think. I'm not 100% sure if she actually did.
So that's a yes to my question. You do think the defendant texted Alex Cifuentes?
I think, but I'm not for sure, if that makes sense.
Now, I would like to move on and talk about your involvement on the team. Now, 1 week before regionals, you quit the mock trial team, correct?
I did.
And you quit in support of your friend, the defendant, who was kicked off.
It was in support of my friend and in support of the team. I always put the team first.
So, Mr. Perkins, is that a yes to my question? You quit in support of the defendant and the team?
Yes, I did quit in support of Avery. That was only part of it, though.
But Mr. Perkins, you know the defendant well, correct?
Well, Avery was one of my best friends. I would say I knew her pretty well.
Exactly. You and Avery were best friends.
Objection, Your Honor. I would like to ask that Ms. Radowski ask or refer to Ms. Becker with respect in using her last name and or her full name instead of the first name.
I'm going to let counsel conduct their case however they see fit. You may proceed.
No, Mr. Perkins, you and the defendant were best friends, correct?
I would say we were best friends, yes.
And you are also the only one here today in court who can corroborate the defendant's alibi for March 6th, correct?
See, there wasn't like a spy following us. That'd be weird. Like a spy that could testify like, oh yeah, these two people were together. I mean, security camera footage could do that, like at the mall, but we're the only two people here today.
So, Mr. Perkins, just to clarify, is that a yes to my question? You are the only one.
Yes, we were the only two people here today testifying that we were together.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. Mr. Perkins, tell us more about why you quit the mock trial team.
So, like I said, Avery was the best attorney on the team. I mean, by far. Having her not on the team would be like the Rockies not having Nolan Arenado, which kind of hurts right now. But it just didn't make sense for her not to be on the A team where she belonged.
All right. And on March 6th, were you two together the entire day?
Yes, we were together the entire day looking for her phone. I mean, other than like the 2 minutes she was in the bathroom, but I didn't follow her in. That would have been weird. But she had to be like the Flash to go from the bathroom at the mall to Coach Brackman's house and back to the mall. As far as I'm aware, she's not the Flash. So I don't think that's possible.
Thank you, Mr. Perkins. Your Honor, I have no further questions at this time.
All right. If there is nothing further, the witness may step down.
Thank you, Your Honor.
And you may call your next witness.
Your Honor, the defense calls Blake Van Owen to the stand. May I proceed?
Go ahead.
Good evening, Mr. Van Owen. Please introduce yourself to the jury.
Good evening. My name is Blake Van Owen. That's spelled Van Owen.
Let's talk about your professional career. How did you get involved in criminal justice?
I have always had a passion for criminal justice. That's why I became a police officer. As a result, I joined the Aurora Police Department in 2005.
Are you currently a police officer?
Heavens no. It turned out that my definition and their definition of criminal justice were significantly different. So I left in order to pursue education and investigation.
Tell us about your experience in education.
I obtained my master's degree in criminal justice from Ashford University in 2014. Shortly thereafter, a year after, in fact, I began lecturing students at the University of Colorado on police practices and social justice.
Tell us about your experience in investigation.
I've been a private investigator for several years now. I like to consider myself as a check on the power of police.
Have you ever testified in a court of law?
I've consulted as an expert in over 100 cases. I regularly act as an expert in both federal and state courts.
In those courts, in what fields were you qualified, recognized by the court as an expert?
I was accepted as an expert in crime scene reconstruction 8 times, cell tower analysis 5 times, and general police procedures 12 times.
Your Honor, the defense requests the court to recognize Professor Van Owen as an expert in the field of crime scene reconstruction, cell tower analysis, and police procedure.
Anything from prosecution?
Yes, Your Honor. I object specifically to the tendering of Professor Van Owen in crime scene analysis and cell phone tower analysis. Crime scene reconstruction, pardon.
May I respond, Your Honor?
I'd first want to hear what are the grounds for the objection?
Of course, Your Honor. Professor Van Owen has testified that he has testified as an expert in cell tower analysis 5 times in the past, but experience testifying in court does not constitute experience in the field, which is required by Rule 702 to be tendered as an expert in cell tower analysis. Additionally, we do not have any, Mr. Powell has not laid any foundation as to what experience, training, education, skill, etc. Professor Van Owen received in his master's degree, and therefore I believe there has been a lack of sufficient foundation for Professor Van Owen to be tendered as an expert in crime scene reconstruction and cell phone data analysis.
Defense counsel, a response?
Your Honor, pursuant to Rule 702, Professor Van Owen's skill, knowledge, education, experience, or training has been shown. Professor Van Owen has been recognized by previous courts in cell tower analysis and crime scene reconstruction. Therefore, experience and knowledge, and in fact, everything qualifying him as an expert under 702 has been shown.
Your Honor, if I may respond.
Go ahead.
Once more, experience testifying in court does not constitute experience in the field. Yes, perhaps Professor Van Owen has been tendered as an expert previously in crime scene reconstruction and cell phone data analysis, but he has described no experience within the field itself other than simply testifying in court.
Counsel, this is what I'm going to do with regard to this objection. I am going to hold on to this right now. And defense counsel, if you can lay some further foundation so they can decide on this, I'll let you proceed with your questions before you offer him as an expert.
Yes, Your Honor. Professor Van Owen, what specifically did you learn in the police academy while you became a police officer?
Before I joined the department, there is a training course where I did learn the ins and outs of cell tower data. Also, I have a master's degree in criminal justice where I did learn skills inquiring cell tower analysis.
What about crime scene reconstruction?
The same applies with crime scene reconstruction. We learned skills at the police academy along with skills during my time at college.
Your Honor, the defense requests the court to recognize Professor Van Owen in crime scene reconstruction, cell tower analysis, and police procedure. pursuant to Rule 702, his skill, knowledge, education, experience, and training have been shown.
The court accepts him as tendered as an expert in those named areas.
Yes, Your Honor. Professor Van Owen, what did you do to start your investigation or start your consultation of this case?
First, I was hired by the defense as a private investigator to perform an analysis on prosecution witnesses and their reports.
Let's talk about Kyle Kuzak's report. What problems do you have with his report?
I've met Kyle Kuzak, and there's no problem with who he is. The problem stems from his investigation only highlighting the shortcomings of Detective Markowitz's.
How so?
You see, Kyle Kuzak's entire investigation only shows Detective Markowitz's failure to interpret evidence.
Let's talk about Detective Markowitz. In your review of her report, what problems do you have with that?
Frankly, Mr. Powell, Detective Markowitz suffers from a case of confirmation bias.
What is confirmation bias, Detective? Excuse me, Professor.
It is the tendency to interpret new evidence as confirmation of one's existing beliefs.
How does Detective Markowitz fall victim to this?
You see, Detective Markowitz developed a preconceived notion that Miss Becker was the only suspect in today's case. She only focused on and noted evidence that would implicate Miss Becker while ignoring evidence that would exculpate her.
What are some examples of this?
First, Detective Markowitz's assumptions on the cell tower data. Second, the validity of the text message screenshots. And third, the detective's lack of an investigation on Blair Rollins.
Let's talk about the cell towers. How is this an example of confirmation bias?
Before Detective Markowitz pulled any of her data from the cell towers, she had her suspect, and that was Miss Becker. Instead of following the data to their natural story, Detective Markowitz tried to force the data to fit in her story, just like a puzzle piece in the wrong puzzle.
How so?
You have to understand that cell tower data is not like a GPS. You see, cell tower data is ample in finding the general location of a phone. However, it is impossible for it to pinpoint the exact location of a phone. For example, even if the phone was in the cell tower arc, it could have been in a 37.7 square mile radius of that arc.
And did Detective Markowitz find any evidence to suggest that Miss Becker even had her phone?
No, they did not. They just assumed that Miss Becker was in possession of the phone.
Let's talk about the screenshots. How is this an example of Detective Markowitz's confirmation bias?
You see, there are two aspects of confirmation bias within Detective Markowitz's analysis of the text message screenshots. She fails both on figuring out who sent them and from where they were sent.
Why don't we know who sent them or where they were sent from?
The name on an iPhone can be easily manipulated. To figure out from where the messages were sent, you have to actually download the data from the phone. Look, the detective is an expert in downloading cell phone data, yet she didn't download any of the data on this phone at all. No, she took the messages for face value so that she could easily confirm her existing beliefs.
Let's talk about Blair Rollins. Who is he?
Blair Rollins was a student at Colorado High School.
How is he related to this case?
Blair Rollins' father, Jonathan Rollins, was convicted of first-degree murder. The Rollins family depended upon Mr. Brackman to defend Jonathan in court. Jonathan was sentenced to life in prison. After the sentencing, Jonathan actually yelled a threat.
What did he yell?
He yelled, "I'm going to get you back, Brackman, if it's the last thing I do."
What evidence did you find about Blair Rollins?
Hearsay?
Sorry, counsel, could you repeat?
Yes, objection hearsay.
Any response to that?
Your Honor, pursuant to Rule 8032, this is an exception to hearsay. This is an excited utterance. Jonathan Rollins yelled this statement after being under the stress of a startling event, being sentenced to life in prison.
Any response to that, counsel?
Yes, Your Honor. I believe that the statement is being used for the truth of the matter to, in fact, help go to the defense's opinion of Mr. Rolling's motive. Additionally, I believe that there has been a lack of foundation to prove that this was, in fact, an excited utterance.
I am going to overrule that objection. I'm going to allow it. Counsel, you may continue.
Professor Van Owen, what did Jonathan Rollins yell at Mr. Brackman?
He yelled, "I'm going to get you back, Brackman, if it's the last thing I do."
All right, so what evidence did you find about Blair Rollins?
Blair Rollins was at the court proceeding when this happened. And furthermore, Blair Rollins has a significantly stronger motive than Avery Becker.
What other evidence?
Blair Rollins was missing from school on the day of the murder. If Blair were to blame Mr. Brackman for his father's sentencing, this gives him the perfect opportunity to kill Mr. Brackman.
All right, so now that we know who Blair Rollins is, how is Detective Markowitz's lack of an investigation into her or into him an example of confirmation bias?
Detective Markowitz based his conclusions on 4 facts: a motive, a threat, a phone in the cell tower arc, and a missing person. The reality is each of these facts is true of Blair Rollins. Rollins had a motive. Rollins made a threat. Rollins' house was in the cell tower arc, and Rollins was missing from school and is still missing today. Detective Markowitz didn't follow up on Blair Rollins because she thought that she completed the puzzle. Detective Markowitz was aware of all of the evidence that implicated Miss Becker, but no, that was too much of a bargain for her. So she settled for Avery Becker. If the pieces did not fit Detective Markowitz's picture of the puzzle, then she just ignored them. This is clear confirmation bias, and this is clearly a failed investigation.
Thank you, Professor. Your Honor, I have no further questions at this time.
Cross?
Yes, Your Honor. Good afternoon, Professor Van Owen.
Good afternoon.
I'd like to talk to you about something you said on direct. On direct, you talked about some of the specifics of your training, about how the police academy taught you the ins and outs of crime scene reconstruction and the ins and outs of cell phone data analysis.
That's correct.
But you said that nowhere in your witness statement today, did you?
No, it's common knowledge that in the police academy, you learn how to reconstruct a crime scene along with cell tower analysis.
But just to confirm, that is nowhere in your witness statement?
Objection. No. Answered, Your Honor.
I believe it was answered, so let's move on.
Yes, Your Honor. Now I'd like to briefly talk to you some about your background. You were once a police officer?
That is correct.
You were only a police officer for 9 months.
That's correct.
And you became disillusioned with police work.
Some of the stuff that I saw at the Aurora Police Department, it angered me, and I needed to leave. I needed to fix these problems.
So you became disillusioned with police work because of its tactics and techniques, correct?
That's correct.
And you now teach and as a result of those tactics and techniques, you quit your job as a police officer, correct?
I stepped down, yes, so that I could start my own career, educate myself more. I became a professor.
Of course, and you now teach a college course on police practices and social justice.
I do, yes.
And you frequently testify as an expert in court.
I do, yes.
But you only ever testify for the defense.
You have to understand that the police have experts that are already provided to them, while the defense do not. If the police wanted me to testify for them, I gladly would. However, they have never reached out to me, so I have not, no.
And you consider yourself a check on the power of policing, correct?
Yes, I do.
Now I'd briefly like to talk to you about some of your findings in today's case. You agree that some of the evidence found at the scene points to an intruder entering the home.
Yes, that's correct.
You're aware that scuff marks were found at the scene of the crime.
They were, yes.
You're aware that a broken plate was found in the dining area,
Yes, I am.
that a chair was found overturned in the dining area as well.
Yes, and there are several explanations to all of these, other than a struggle.
Professor Van Owen, you're getting a bit ahead of me. I'm not asking about the other possible explanations. I'm just asking that you're aware of this evidence. And you
I
are.
apologize. Yes, I am aware of that.
You're also aware that a knife drawer was found opened in the kitchen,
Yes,
and that there was a knife block found on the counter missing a knife with an empty knife slot, pardon me.
that's correct. Again, none of these are a sign of a struggle, though.
Once more, Professor Van Owen, I'm not asking if these are signs of a struggle, simply that you are aware that these pieces of evidence were found at the scene.
I am, yes.
And you're also aware that the defendant wasn't at school on March 6th.
Along with Blair Rollins, yes.
Professor Van Owen, once more, I'm not asking about where Blair Rollins was, but simply that the defendant wasn't at school on March 6th. And she wasn't, was she?
No, they weren't.
Now I'd briefly like to talk to you about some of your findings regarding cell phone data analysis. You would agree that a cell phone typically connects to the nearest cell tower, correct?
Oh, I'm sorry. Did you mean cell tower data analysis?
Pardon me, yes.
Can you ask that again?
Of course, Professor Van Owen. You would agree that a cell phone typically connects to the nearest cell tower, correct?
You have to understand that, no, not typically. It's a higher percentage, I would say, connects to the nearest tower. However, it does not always connect to the nearest tower.
So you think it's probable that a cell phone could connect to a more distant tower?
Yes, very probable.
But you would agree that it is more likely for a cell phone to connect to the nearest cell tower?
Yes,
You're aware that cell tower 1197 is near the Brackman residence.
I am.
And the cell tower typically has 3 antennas.
That's correct.
Each antenna covers a 120-degree arc.
Yes, in a 37.7 square mile radius.
Of course. Now, antenna number 1 of cell tower 1197 covers the Brackman residence, correct?
That's correct. It also covers Blair Rollins' residence.
Professor Van Owen, I think you're confused about what cell tower.
Oh, my apologies. No, yes, it does cover Mr. Brackman's. I'm sorry. I thought you were referring to the other cell tower.
That's all right, Professor Van Owen. So Avery Becker's phone connected to antenna number 1 of cell tower 1197. Did it not?
The phone did. However, that does not mean Avery Becker was in possession.
But Avery Becker's phone connected to cell tower 1197 3 separate times, did it not?
That is correct.
It connected at 1:05 p.m.
Yes.
Once more at 1:06 p.m.
Yes, and this, again, does not suggest that the phone was at Brackman's house. It could have been in a 37.7 square mile radius of that tower.
Professor Van Owen, I'm not asking if Miss Becker's phone was at the Brackman residence, but simply that it did connect to cell tower 1197 at 1:06 p.m. And it did, didn't it?
It did, yes.
It also connected at 1:17 p.m.
It did, yes.
So Avery Becker's phone connected 3 separate times to cell tower 1197 around the time that Mr. Brackman was murdered, correct?
Mm-hmm. Just to be clear, Avery Becker's phone did, yes.
Thank you. No further questions.
Counsel, any redirect?
Yes, Your Honor. Professor Van Owen, why do you only testify for the defense?
As I said earlier, the police are handed down experts that are provided to them, whether the defense or not. Again, if the police wanted me to testify for them, I gladly would. But they have not contacted me.
Do you know where Blair Rollins was on March 6th?
No, I do not.
Was she in school?
They were not at school, yeah. That is all I know, that they were not at school.
And where was Avery Becker on March 6th?
Avery Becker was at the mall with Taylor Perkins looking for her phone.
All right, let's talk about the cell towers once more. Are cell towers in any way a GPS?
No, not at all. Again, they are only ample in finding the general location of a cell phone. They do not pinpoint the exact location of a phone.
So say Miss Becker actually did have her phone and she was near the residence of Mr. Brackman. How far away could she be to ping in that tower?
She could have been in a 37.7 square mile radius of that tower.
So, in your expert opinion, is cell tower detail or call detail records in any way indicative of an exact location?
No, in this case, Detective Markowitz attempts to use the cell tower data like a GPS. Again, taking the easy way out.
Thank you, Professor. Your Honor, I have no further questions.
If there's nothing else, the witness may step down. Does the defense have another witness to call?
Yes, Your Honor, we call Avery Becker to the stand.
You may proceed.
Good evening, Ms. Becker. My name is Ashlyn Vierig. Please introduce yourself to the jury.
Good evening. I am Avery Becker. That's Becker.
Let's start by talking about your relationship with Mr. Brackman. Many witnesses have testified to it. Why was it so strained?
We were just very different. We had such different styles when it came to work, especially mock trial. I'm a more natural, kind of go with the flow type of person, and he's just very scripted.
Was it hard to have a meaningful relationship with him?
I think it's hard to have a relationship at all with someone who just doesn't appreciate you.
Now, we've heard a bit about events that added to the struggle with Mr. Brackman. Let's hear your side of the story. When you were demoted to B team, how did you react?
I was upset, but I still wanted to get my best attorney award. I just, kept working and doing my thing. And Taylor actually later quit and I was reinstated to the A team.
How did the regional tournament go once you were back on the team?
It actually went really well. I won the Best Attorney Award and Best Closer. I thought I finally proved myself and proved my position on the A team, but Coach thought otherwise.
What do you mean by that?
The first practice after regionals, he just started going off at me, just saying that I only won my awards because of luck and my good looks.
How did you respond?
I was upset. Coach had just insulted me in front of my team. I stormed out of practice with what I thought was a dry erase marker and I wrote on Coach's car.
How did you apologize to your coach?
First, I tried texting him. I offered to scrub his car or even get a job over the summer to pay for repainting, but I never got a response. So I tried seeing him in person. I went to his work and practice, and he refused to see me. And now he's gone, and I'll never get to apologize.
How did all of this make you feel?
I was devastated. I just wanted to make things better.
I'm sorry, Ms. Becker. I know that must have been hard. We can move on. We've heard a lot about your phone today. Let's talk more about that. You should have access to Exhibit 14, so please refer back to this. Do you know what these are?
These are the text messages the prosecution is claiming I sent.
Could you have sent these?
No, it's literally impossible. I lost my phone. I still haven't found it. It's been gone. I had to buy a new one.
Where was the last place you saw your phone?
The Fry Shack. Taylor and I were playing video games. We were actually playing Among Us. Great game, highly recommend. And then I needed to use the restroom and I must have left it on a table or something.
Who else was there?
The mock trial team. and Alex Cifuentes.
After you lost your phone, what did you do?
Taylor and I skipped school the next day to look for it. We looked for it at the mall and the Fry Shack.
And when did this search occur?
March 6th.
Why do you remember that day?
That's the day Coach died.
Let's talk about Blair Rowlands and Alex Fuentes. What do you have to say about your relationship with Alex Fuentes?
We were not friends. We were teammates. She constantly thought of me as her biggest competition, and it was after the awards
Objection, Your Honor. Speculation.
Response, Your Honor.
Go ahead.
Under Rule 701, this is rationally based on the witness's perception. She is testifying to the relationship between herself and Alex Fuentes, and she has plenty of experience centered around this relationship.
Your Honor, may I respond?
Go ahead.
This witness specifically testified as to the mindset of Alex Cifuentes. This witness doesn't have personal knowledge of what Alex Cifuentes was thinking or how Alex Cifuentes felt. She testified that they were teammates, but wasn't sure they hung out outside of that. So she really just does not have the personal knowledge to know that information.
I'm going to sustain the objection at this time. Counsel, if you're able to lay additional foundation for that, go ahead. Otherwise, that response will be stricken.
Yes, Your Honor. What do you know about Alex Fuentes?
She was on the mock trial A team with me. We didn't have the best relationship. I just constantly felt like that she was after the awards I was winning, and that she thought of me as her competition. That's just what it felt like.
Would you ever go to her for help?
Absolutely not. She would be the last person I would ever go to for help.
Now, do you know Blair Rowlands?
Yes, I think he hated Coach because his dad was represented.
Objection, Your Honor. Speculation.
Response, Your Honor.
Go ahead.
It's based off of Rule 701. Again, it is rationally based on the witness's perception. She went to the same school as Blair Rowlands, and she was she spent a lot of time with Coach Brackman, so she could reasonably assume things based off of her knowledge.
Your Honor, may I respond to that?
You don't need to at this time. I don't think that there's enough in the records to substantiate that line of testimony. I'm going to sustain the objection. Counsel, you may proceed.
Do you know who Blair Rowlands is?
Yeah, he was friends with Alex Cifuentes.
What else do you know about him?
Well, Coach represented his dad in a murder trial, and Blair Rowlands was sadly.
Lack of foundation.
Sorry, counsel, could you repeat that objection?
Lack of foundation, Your Honor.
A response?
Your Honor, I don't see how this can be objected to by lack of foundation. I'm simply asking a question about Blair Rowlands and what she knows about him.
It seems at this point that these questions are foundational in nature themselves, so I'm going to overrule the objection, allow the questioning to continue.
I'll re-ask my question. What do you know about Blair Rowlands?
His dad was represented by Coach in a murder trial, and Blair Rowlands' dad was sadly convicted of murder and sentenced to life in prison.
Now, Ms. Cifuentes, you've been here through the entire trial, or Ms. Becker, you've been here through the entire trial. You've heard many different witnesses testify many different things. I'm going to ask you the one question that everyone wants to know. Did you kill Coach Brackman?
No! No! I couldn't kill anyone.
Why should we believe you?
It's no secret that Coach and I didn't get along, and especially after the card, but to go to his house, to break in, to stab him? No, that's not me.
Thank you, Ms. Becker. No further questions, Your Honor.
Counsel, do you have anything?
Yes, Your Honor. Just one moment and I'll get started. Good evening, Ms. Becker. I have just a few questions for you tonight.
Good evening.
On the day of March 6th, you weren't present at school, were you?
I was at the mall in the Fry Shack looking for my phone. No, I wasn't.
So because you weren't at school, you were, as you said, you claimed that you were at the mall, correct?
I don't claim. I was at the mall. I was there with Taylor Perkins.
And Miss Becker, the only other person here in court today who can claim to have seen you that day is Taylor Perkins, correct?
Only one at court, but you probably could have gotten security cameras or some random person from the mall that recognized me, but yeah.
Ms. Becker, I'm not asking about what we could have done. I'm asking about if Taylor Perkins is the only other person here who can testify to seeing you on March 6th. And that's true, isn't it?
Yeah.
And before March 6th, Coach Brackman used to coach your mock trial team, correct?
He did.
Mr. Brackman always told you that you were lazy, didn't he?
He did.
Mr. Brackman didn't give you the credit for your work that you felt you deserved, did he?
I just wanted to make him proud. He never even acknowledged it. He just, I don't know. All I wanted to do was make him proud, and he never acknowledged.
My apologies, Ms. Becker. Because you wanted to make Mr. Brackman proud, those comments were upsetting to you, weren't they?
It hurt. It hurt a lot.
And just 1 month before your regional tournament last year, Mr. Brackman demoted you from the A team down to the B team, didn't he?
He did, and I still don't understand why.
And Mr. Brackman took away your closing argument.
He did, which I didn't understand as well.
And Ms. Becker, you thought the B team was full of losers, correct?
That is something that I said. It was a rude comment, but I did say it.
And because you thought the B team was full of losers, you tried everything to get back onto the mock trial team, didn't you?
I just wanted to help my team, and I felt like I would help the team win regionals and go to state. So yeah, I did want to get back on the A team, but it wasn't necessarily because the B team were full of losers. I worked hard. I deserved my spot on the A team.
So Ms. Becker, you did try everything to get back on the A team, correct?
Yeah, I guess I worked really hard and I kept doing my thing, but actually Taylor quit, and that's how I got reinstated. I guess
Exactly.
he just,
My apologies, Ms. Becker. Exactly. Only after Taylor Perkins quit did Mackenzie Brackman let you back onto that A team.
I guess Taylor didn't really like doing mock trial without me, but yeah, that's when coach let me back on.
And Ms. Becker, at that regional tournament, you won some awards, didn't you?
I did. I won the best attorney award and the best closer. I worked so hard for it. I was so proud.
But Ms. Becker, just a little bit after that, Mr. Brackman told you you didn't deserve those awards, didn't he?
He did the next practice in front of everybody.
He told you that you got lucky, didn't he?
He did. I just wanted to prove myself and have him be proud of me. That's all he did.
And Ms. Becker, this actually at that practice made you angry, didn't it?
It did.
And because you were angry, you stormed out of practice.
I did, and I took a dry erase marker and wrote on Coach's car. It was so stupid.
Ms. Becker, you've gotten just a little bit ahead of me. But after you stormed out of the practice, you went out to the parking lot, correct?
I did.
And you saw Coach Brackman's car in that parking lot.
I did, and I did something I regret, which I already said.
Ms. Becker, you knew that Mr. Brackman loved that car, didn't you?
He did. It was a part of him.
And you went over to that car and you wrote Worst Attorney Award on Mr. Brackman's beloved car, didn't you?
I thought it was a dry erase marker. I would have never done it if it was a permanent marker. I didn't mean to, but I regret it, and I wish I just could make it better.
Ms. Becker, I'm not asking if you regret it or what you meant to do. I'm asking what you did. And you did write on Mr. Brackman's car, worst attorney award, didn't you?
I would have never known if I would never have done it if it was permanent, but I did do it.
And after that, Mr. Brackman came outside and saw what you had done.
He did.
He yelled at you.
He did.
He kicked you off the mock trial team permanently.
And I completely deserved it. He did.
And that made you even angrier than you had already been.
I would say mad, but yeah.
So you were even madder than you had been before, correct?
Yes.
And then you went home that night, didn't you?
I did. I was very upset, and my mom calmed me down.
And you told your mom specifically that Mr. Brackman had gotten on you for no good reason. Isn't that true?
I was embarrassed of what I did. I didn't want to tell her yet, but I did tell her eventually. But that's what I told her that night.
And then you told your mom that you were going to get back at Mr. Brackman if it was the last thing you ever did, didn't you?
It was so petty of me to say that, especially after everything that's happened, but I did say that.
Thank you, Your Honor. No further questions.
Anything more for this witness?
Yes, Your Honor. Redirect. Ms. Becker, did you want to get revenge for being kicked off the team?
Of course not. I just wanted to make things better.
Thank you. No further questions, Your Honor.
All right, the witness may step down. Does the defense have any other witnesses to call?
No, Your Honor, the defense rests and closes.
All right, that's it with the witness stage. The prosecution will now have its closing argument.
Yes, Your Honor, just one moment. Your Honor, I also ask that my co-counsel, Ms. Radowski, please be allowed to screen share exhibits.
Yes, that's fine.
She wanted revenge. She got more than she bargained for. Avery Becker needed revenge. She had vandalized her coach's car. She'd been thrown off her beloved mock trial team. She had to raise the stakes. She had to get even. So Avery Becker put on a disguise and went to Mackenzie Brackman's home to trash it. She didn't expect Mackenzie Brackman to be there, but he was. She didn't expect Mackenzie Brackman to have a knife, but he did. She didn't go to Mr. Brackman's home intending to kill, but she left a murderer. She wanted revenge. She got more than she bargained for. Today, the prosecution has charged Avery Becker with murder in the first degree and burglary in the second degree. This means that today we had to prove to you that Avery Becker unlawfully broke into Mackenzie Brackman's home, and that while she was there, she caused the death of Mackenzie Brackman. Now, members of the jury, today the prosecution did not have to prove that Avery Becker ever went to Mackenzie Brackman's home with the intent of killing Mackenzie Brackman, only that while committing burglary in the second degree, Mr. Brackman died. And we had to prove these things to you today beyond a reasonable doubt, which is exactly what we've done by showing you how the defendant wanted revenge and how she got more than she bargained for. It's actually quite simple. On March 6, 2020, Avery Becker had a score to settle. She was mad about being thrown off the mock trial team, mad that Mackenzie Brackman had taken away the thing that she loved, mad that Mackenzie Brackman had never given her the credit she felt she deserved. She wanted to make Mr. Brackman feel just a little bit of the pain that she had felt. She wanted to trash his home. And members of the jury, you saw today the text messages that Avery Becker sent to Alex Cifuentes, spelling out for you, word by word, her intent to break into Mackenzie Brackman's home as payback. And today, you don't even just have to take the defendant's own words for it, because we know where Avery Becker was on March 6th. We know that Avery Becker was at Mackenzie Brackman's home. You heard today from Detective Markowitz that the defendant's phone connected to the cell phone tower covering the victim's home. A cell phone tower the defendant's phone never should have connected to. A cell phone tower the defendant's phone connected to 3 separate times. Once might be a chance, twice might be a coincidence, but 3 times is proof. We know the defendant was in the area. We know it was the defendant seen on camera in the ring videos, entering and fleeing Mackenzie Brackman's home, that their size and builds match exactly. We know that Avery Becker wanted revenge, and that she got more than she bargained for. Members of the jury, today the defense tried to tell you that justice doesn't always come in a box with a pretty little picture on top. But members of the jury, the evidence in today's case points to one suspect, one person who committed these crimes. We're asking you to see that Avery Becker wanted revenge, and that when she went to get it, when she went to vandalize Mr. Brackman's house, she got more than she bargained for. What she got was murder. We ask you for a verdict of guilty. Thank you.
May I proceed, Your Honor?
Yes, you may.
Justice does not come in a box with a picture on top. It's Friday, March 6th. Detective Markowitz arrives at the scene and immediately finds Coach Brackman lying dead on the floor. So she starts trying to put the pieces of the puzzle together. A dead body, a bloody knife, and some home security footage. But what she does not have is any fingerprints, or any DNA, or any suspects. So Detective Markowitz got more than she had bargained for. And she begins trying to force these pieces of the puzzle together into the amalgamation which she presented to you today. Along the way, she talks to Alex Cifuentes, only one member of the mock trial team, and finds the picture that she hopes to create. That picture is Miss Becker. Along the way, she misses several critical pieces to this puzzle. A credible alibi, an alternate suspect, and a scheming witness. Your Honor, counsel, members of the jury, my name is Madeline Proctor, and together with Ashlyn Vierick and Chalmers Powell, we had the privilege to represent Miss Avery Becker, a flawed but innocent young woman. She did not want revenge. She wanted to make amends. Miss Becker had the right to remain silent, but instead she chose to tell you what really happened on March 6th. She was with her friend Taylor Perkins all day, and she did not know where her phone was. And you can believe her because you did listen to those 3 things: a screenshot, cell towers, and a stronger suspect. A screenshot. Can't trust it. The prosecution wants you to believe that Miss Becker sent that screenshot. Really? Alex Cifuentes, a suspect in this case, is the one who gave them that screenshot. You remember her. She's the one who does twice the work and gets none of the credit. She's the one who conveniently forgot her phone the night of the interview. And she's the one who waited a full day to send Detective Markowitz that screenshot. Those messages were faked. But more importantly, members of the jury, you cannot trust that screenshot because Detective Markowitz failed to do her job. She was entered today as an expert in cell phone data recovery, but the only data she recovered was from the victim's phone. She did not recover any data from Mr. Perkins' phone to confirm the alibi. She did not recover any data from Ms. Cifuentes' phone. Detective Markowitz did nothing to confirm that those text messages were even real. This cell phone data recovery expert took those screenshots at face value. Cell towers. The cell towers are just dangerous enough to accuse Miss Becker, but too vague to prove anything. Not only did they not act as a GPS, but Miss Becker did not have her phone. The phone can ping wherever it wants to. Miss Becker did not have it. And a stronger suspect. The prosecution wants you to believe that Miss Becker was the one in the mask, the hoodie, and the gloves. In reality, members of the jury, there is one suspect who fits that description, that height and build, and the puzzle perfectly. Blair Rollins, the suspect who blames Coach Brackman for the death of his father. The suspect who lives in the same cell tower arc as the defendant. And the suspect who was missing then and is still missing now. That's right, Detective Markowitz never interviewed Blair Rollins. She never talked to him. She never even located him. Members of the jury, the prosecution holds the burden of proof in today's case to prove each and every element of each and every crime beyond a reasonable doubt. A screenshot, cell towers, and a stronger suspect. Each is reasonable doubt. They have failed you. In just a moment, Ms. Ryan will get back up here and try to wipe away everything we just talked about. Don't let her. Ask her this question and make her answer it. If Detective Markowitz was really an expert in cell phone data recovery, why didn't she take the simple step of downloading Ms. Cifuentes' phone? Because justice does not come in a puzzle box with a picture on top, Detective Markowitz. Find Avery Becker not guilty. Thank you.
Prosecution counsel, I see you have some time left for rebuttal. Do you choose to make one?
I do, Your Honor. Now, Ms. Proctor just got up here and told you that this case was a puzzle. But members of the jury, today, all the pieces fit together into one clear picture, a guilty one. Today, you saw the defendant testify. The only time that she was happy during that testimony, members of the jury, was when she was talking about mock trial because she loves it more than anything. So when it was taken away, it was just too much. She texted Alex Cifuentes and begged for help getting back on the mock trial team. She threatened to go to Mr. Brackman's house and trash it, which is exactly what she tried to do. You saw today that her phone connected 3 times to a cell phone tower that it never even should have been remotely close to. Members of jury, today we've seen a guilty puzzle. We ask you for a verdict of guilty. Thank you.
Thank you, counsel. The case is submitted to the jury for scoring.
We are still waiting on a few of the scorecards, so you guys can go ahead with remarks while we get this worked out.
Great, thanks for letting us know. I was waiting until those were done. Since I'm not providing any scoring, I'll give a little bit of feedback to the teams while some of our scoring panel is still filling those out. And I'd like to thank everybody on the teams, the attorneys, witnesses, and other folks on the teams who've been helping out today. I think you all did a very good job. As high school students, you've got a full caseload, full class load on top of everything that you're doing to prepare for this. So I can really appreciate the extra time that you took to do it. You all were very prepared. I enjoyed some of the witnesses, definitely a lot of character role playing going on. In the teams, I think did a good job with the direct and close, in the crosses as well. One thing that I thought was very interesting, and you all have probably run into this because you've been doing it a number of times already. This is not the first trial you've done. Is sometimes running into trouble on cross examinations, and I think you all have handled that very well. It's difficult to control witnesses, especially ones who are on a different team, and I think you all did a very good job with that. One of the things that I noticed in receiving objections, and you all may have seen this as well, sometimes foundation objections are very well made and very accurate. On the other hand, they educate your opposing counsel on what it is they need to do to make a better case. So sometimes that's just a very strategic decision that you all have to make. Do you want to make that objection, maybe throw the other side off or exclude evidence, or do you want to leave a trail of breadcrumbs on here's what it is you need to do to make this witness and their testimony more believable? So that's kind of one of the little things that I think that we saw today. In most instances, I let in most of the evidence, and folks did a very good job establishing that foundation if it wasn't put in the first instance. But I enjoyed sitting here. This is the first high school mock trial competition I've done. I've judged appellate arguments for law students, and I'll tell you, I think that you all were very, very well prepared yourselves. So I don't know if we have any of the scoring panel folks who are ready to break in yet.
Yeah, absolutely. Great job, everyone. That was awesome. This is also the first one I've done for scoring, but incredibly impressive. I am definitely going to incorporate some of the stuff I saw in my own trial practice out there. It was very cool. Just some general pointers for, he brought up cross. I think everyone kind of struggled with this as far as kind of just stating a statement instead of asking it as a question. When I'm drafting an outline, I like to just ask every question as a, isn't it true that, and then keep going with that. But loved all the accents. Thought that those were great. For defense, I heard you guys say the word murder many times from the defense side, which if you're trying to defend someone for murder, may not be a word you want to say very often. But those were, dead body, person is deceased, things like that. But you don't want to be reminding people that someone was murdered if you're saying someone was not. But I thought you guys did a great job, and congratulations.
Hey, everyone. I also want to echo great job. Currently in round 3 of the state tournament, so I know you guys have all put a lot of work into this, and I've judged all 3 rounds in this tournament so far, and I have to say this is probably the best performance I've seen out of both teams. I really loved how both of you guys had strong themes that you remembered not just to hammer in during your openings, but to echo during your closings, and how both teams work to flip their themes on each other. I think that was really great. On the witness control, I actually did want to point someone out who I thought did a really spectacular job. Madeline, your witness control while being controlling without coming across as too harsh. I think that was a really standout performance for me. Other than that, really, just really fantastic job. Give yourselves a hand. Just that was really great.
All right, I guess it's my turn. And so I will echo what everyone is saying and say, yeah, you guys did an excellent job. I think you guys were a good match. This one was a tough one to score today. This is my third year doing this, and I have to say I am always beyond impressed. I'm in court quite a bit, and I can say that a lot of you guys do better than a lot of attorneys I see every day. So if you're really thinking about going to law school, you guys are so many steps ahead of, I know where I was. I wish I had something like this in high school. So yeah, I mean, you guys did a great job, and I know I can really tell that you put a lot of hard work and effort into this. So yeah, you should all be very proud of yourselves. I guess just a couple of things I want to comment on. I thought you guys did, for the prosecution, I was super impressed with the, sorry, I don't remember names, but the cell phone tower expert. I really liked what you did with that exhibit and how you marked it up. That kept me really interested. And I thought it was really cool how you asked to, reserve the right to use that as a demonstrative exhibit in your closing. I thought that was really good. And then defense, your expert witness, sorry, again with names, I guess it was Blake Van Owen. I thought the direct and that witness did such a good job at kind of impeaching the other experts and being like a rebuttal witness. I thought that was excellent. You guys did both did good with your themes. It was really easy to keep up with what your themes were. I guess the only critique I would really say is I know some of you didn't do redirect, and sometimes you really don't have anything to redirect. But I think it's important sometimes that you try to do it, because it's kind of the last thing that the jury hears. You don't really want them to hear the last thing that the witness said on cross. So if you can come back with a couple redirects, I just think that's really good, and it kind of helps your case there. Oh, one thing I did want to say, I thought, who was it here? I thought Lily in her cross of Taylor and Jordan in the cross of Avery, I thought they were really good, because I thought both of you did a really good job at kind of keeping the focus on you, which that's where the focus should be on cross. And I think what you did there that was good is you really just slowed down. I know with timing and everything, a lot of times on cross, and then it gets, kind of heated and you're just going really, really fast. But I thought both of you did really good there at just, keeping your pace really slow and keeping the focus on you, because that's where it should be. So that's it. That's really all I have. But you guys all did great, and good luck.
Yeah, I don't really have much to add. Everyone did a fantastic job. I was, I think, equally impressed as everyone else on the panel with everyone's preparation, everyone's knowledge of the rules. And one thing that I was impressed with that I don't think has been brought up yet is pretty much everyone's ability to kind of roll with objections, roll with the punches. There were a few times that technology maybe didn't work, or someone objected and the person who was doing the direct or the cross didn't expect the objection. And it seemed like everyone handled that really well and didn't get flustered, which is can be very hard not to get flustered. And so that's a great skill, to just kind of roll with it, don't freak out, figure out what you're doing and keep going. To Chad's point on the objections, it did feel a few different times like there were maybe more objections than were necessary. Just because you can object doesn't always mean you should, which is, a very hard skill to learn, something that I think experienced trial lawyers are still learning. But just one thing to keep in mind is just because you can doesn't mean it will necessarily advance your case or kind of move the ball forward. And otherwise, I think everyone did a great job. Clearly very, very well prepared.
Great. So I think that's it. I think we're done. I don't know. Do we need to stay on until are all the scores submitted at this point?
Yes, Ashley received everything, so you guys are good to go if you're done with the remarks. Great job, everybody. Thank you.
Thank you,
Thank you, everyone. Good job.
Thanks, and good job, Team Brazil and Charlotte. Bye.